We are recording.
Good afternoon, everyone. Welcome to the Appellate Court. I'm Judge Bright. I'm sitting this afternoon with Judge Mall and Judge Bishop on the matter of Stevenson versus the Commissioner of Corrections, AC docket numbers 41911. We are conducting this hearing over the Teams platform, so everyone is appearing by video conferencing. And I would remind everyone that although this is being done by video conferencing, this is a courtroom proceeding, and we would expect everybody to conduct themselves like they would if they were in the physical courtroom. Lately, unfortunately, we've had a couple of instances where conduct of counsel has been less than what we would expect from people appearing in the courtroom. I don't expect that of the counsel who are appearing before us in this matter, but I feel the need to give that admonition. Second, I will say that this matter is being streamed live over the branch's YouTube channel and will be made available on the branch's website following the argument. To the extent there is any protected information that we would not want to have disclosed, I would caution counsel to be careful about discussing any such protected information. Because this is being conducted remotely, we have a couple other protocols that we do a little bit differently. First, I'm going to ask everyone to keep their microphones muted at all times when they are not talking. The court, the judges will raise our hands if we have questions and ask counsel to recognize us so that we can avoid talking over each other and avoid unnecessary background noises. If you do not recognize us because you're looking down at a particular time, we'll jump in just like we would in the courtroom. But again, we are trying to minimize talking over each other. I would ask that you keep your camera on at all times so that we can make sure that everybody is still present and appropriately engaged. If at any time you lose the ability to hear anyone, please say so. If you lose the ability to see anyone, please say so. And if you get disconnected from the call or from the conference, please click on the link again and rejoin it. We will suspend the argument if necessary until everyone is present. So I am going to ask everyone just to identify themselves for the record so we can make sure we can hear and see everyone okay. Again, I'll start with the judges, then counsel for the appellant and counsel for the appellee. Again, I'm Judge Bright.
I am Judge Mall.
I'm Judge Bishop.
So, Attorney Bright, I cannot hear you. Now, you have you're not, it doesn't appear that you're muted. Do you have, on your end, is your microphone working okay? We cannot hear you. Just hold 1 second. Let me check with Attorney Luke Bond.
Good afternoon, Your Honors. Attorney Luke Bond.
Okay. I can hear and see you okay. Attorney Reich, I can see you okay. I'm going to ask you, Attorney Reich, if you could leave the conference and then click on it and try to rejoin it. Maybe that'll correct the problem.
Can you hear me?
Yes. Yes.
Oh, that's good.
Okay. Okay. All right. So I can hear and see everyone okay. I assume that's true for everyone else. So with that glitch out of the way, we're ready to proceed. Are you ready to go forward?
I am, Your Honor.
All right. Each side will have 20 minutes. Let me know how much time you'd like to reserve for rebuttal.
Probably 10 minutes.
Okay.
Your Honor, this is a case of
accessory. You want to identify yourself for the record first?
Yes, I would, Your Honor. My name is David Rich. I'm the attorney for Terrence Stevenson. At this point in time, Mr. Stevenson has a 60 years sentence to go. He as I said, he was he had he had accessory to murder in violation of Connecticut General Statutes, Section 53A, 54A, parentheses A. He has a very long sentence. What he did, one thing he did do when he was looking through his filings is that he did request relief under the Connecticut Constitution, sections 8 and 9, which is also the same section, I believe, on the Santiago case. So he's really, what he's really looking for is a way to argue that that the Santiago case it's the same. It's basically the same. The same Connecticut constitutional article as section.
Attorney Rich,
Yes.
do you concede that the Second Circuit's decision in Cruz disposes of the federal constitutional claim?
Yes, Your Honor.
Okay, so we're only talking about the state constitutional claim.
That's correct.
Okay, go ahead.
So that is what he's looking at, the Santiago case, in which there's no more. Just give me a second, Your Honor. Basically, the Santiago case made it so that there is no more death penalty in our courts, and my presumption is that it should also be the same for Mr. Stevenson. Right now, with a 60-year sentence, he could very well just expire based on the amount of time he has the amount of time he has to go through his the amount of time he has for his in order to get through his case. He would in all effect probably or could be he might not make it through a 60-year sentence. I think that in this case, the Santiago case should also apply to Mr. Stevenson. In this case, that he.
I think Judge Bishop has a question.
Sure.
Mr. Rush, I have two procedural questions. Commissioner makes a couple of procedural arguments. One of them is that we should hear this because you didn't go through the process of seeking to correct an illegal sentence. And secondly, Commissioner claims that Connecticut briefed the constitutional claim, specifically that you didn't really go through the Geisler factors with any detail, and so that the matter is really not available for our review. I'd like you to address both of those at some point in your presentation.
Yes, Your Honor. Your Honor, I don't have that in front of me. I could if I could draft a brief and present that to the court, I would be willing to do that at this point. If the court is available, if the court is amenable to that. I don't know. Did you hear me, Your Honor?
I guess the question, Attorney Rich, is on the, what is your response to the argument that your failure to address the Geisler factors, not how the Geisler factors would be addressed, but your failure to address them precludes us from reviewing your state constitutional claim?
Well, I think, Your Honor, that one of the issues is the Santiago case, and the fact that my client will be, in all likelihood, not be able to get through his 60-year sentence. I think that's that in and of itself states that that this court is actually allowing for the real possibility that Mr. Stevenson will not be able to get through a hearing. And I think that in itself, the fact that there should be no he shouldn't be in a position where he would be in a position where he probably, in all likelihood, would not be able to go through his sentence, and that's really what the crux of it is for me. Yes.
I don't mean to be overly troublesome, sir, but our jurisprudence tells all who know it that if you want to make a state constitutional claim, you have to make an analysis in your brief under the state constitution. And the state is saying that your brief is bereft of a state constitutional analysis. And Geisler is the case that leads us through several factors that are involved in a Geisler analysis. And the question we're asking you is, do you think you have made an adequate briefing under the state constitutional claim? I understand your claim that this is under Santiago, but that doesn't really address the analysis as to Stevenson under the state constitutional claim.
I understand. I understand your honor. I didn't make that claim in my brief, but I still stand by the fact that if there is a if the court if the court has made law in essence that there should not be that my client should not be in a position where he's likely to not be able to get this 60-year sentence in effect is not should not in effect actually puts him in a position where he's likely to have, basically puts him in a position where he's likely to have a not be able to get through this, and I think that that really should.
Attorney Rich, the Supreme Court said in Riley that a 60-year sentence is equivalent to a life sentence. So that's not the issue here. The question is whether an 18-year-old is entitled to the same protection as a 17-year-old, which was the issue that this court said warranted further review in Miller and remanded in the Miller case. But you keep going back to Santiago and treating this life sentence like it is a death sentence, and no case from the U.S. Supreme Court or the state Supreme Court has said that those two are equivalent. Could you also address the other question Judge Bishop asked, which is, do you have an answer to the Cobham argument that the state has made? You have 1 minute left, as to why you shouldn't have to file a motion to correct an illegal sentence before pursuing habeas relief. The state made that argument in their appellee brief.
I think, Your Honor, that the difference between 18-year-olds and 17-year-olds, there's a lot of there are holdings that an 18-year-old and a 17-year-old, there's not much difference between the two of them, and that although us 18-year-olds do go over
Okay, so that's your 10 minutes. Do you want to use additional time or do you want to reserve the other 10 minutes for rebuttal?
I'll reserve it.
Okay.
Your Honor.
All right. Attorney Lupon?
Good afternoon, Your Honors. May it please the court, I'm Assistant State's Attorney Michelle Lupon, and I am representing the Commissioner of Corrections. With regard to the state constitutional issue, the petitioner has failed to establish a state constitutional right to be treated as a juvenile, and because he has failed to establish that right, he cannot show that the habeas court's return of the writ was legally or logically incorrect. Yes, that's right.
So Attorney Lupon, when the court dismissed the case, the petitioner had been given no opportunity to make the Geisler arguments. And in Miller, this court remanded the case back to the trial court for the trial court to do that state constitutional analysis in the first instance. Why shouldn't the same approach be applied in this case?
Omar Miller is procedurally different from this case. In Omar Miller, the issue was that there is no procedural mechanism for summary dismissal for a motion to correct an illegal sentence. And in Omar Miller, this court specifically contrasted a motion to correct with a habeas dismissal under 2324. So in this case, because we're within the context of a habeas proceeding, there is a procedure under Practice Book Section 2324, Section 3, for...
But the court didn't decline the writ under 2324. It dismissed it under 2329-2 for failure to state a claim upon which relief could be granted.
Your Honor, this order by the habeas court is analogous to the order that existed in Gilchrist versus Commissioner of Correction. And as in Gilchrist versus Commissioner of Correction, the timing of the order and the phrasing of the order suggests that what occurred here was a return of the writ based on the habeas court's preliminary consideration of the application under Practice Book Section 2324. The writ was returned within 2 weeks, or the order was issued within 2 weeks of the filing of the habeas petition, and it was returned prior to the appointment of counsel. Therefore, as in Gilchrist, when a habeas court acts in this particular manner, that is more appropriately deemed a return of the writ under Practice Book Section 2324.
Go ahead, Judge Bishop.
Counsel, I'm troubled by your treatment of 2324 in this instance, your suggestion that this was amenable to being dismissed under 2324. I've always looked at that provision as the gatekeeping provision for the habeas court. And the particular section you're discussing, to me, always meant that it wasn't the sort of thing that is amenable to habeas relief because it doesn't implicate a liberty interest, such as habeas petitioner complaining that the commissioner won't let him go visit his grandmother in the hospital, or complaining that the food is being served for some reason is inadequate. Neither one of those is made up of whole cloth. I experienced both of those as a habeas judge. And I'm troubled by the notion that you think a claim such as this could be summarily rejected from the court without a petitioner ever having the opportunity to make an argument to the court. Why wouldn't this be more amenable to a motion to dismiss or a sua sponte dismissal by the court, with the opportunity, however, for counsel to make an argument, such as Judge Bright just mentioned, in this instance, to make the appropriate state constitutional argument and to try to provide some evidence to the habeas court that could further enlighten the question about brain development and whatever differences there may be between 17-year-olds and 18-year-olds. It just seems to me an expansion of the use of 2324 that, to my way of thinking, is intended to get rid of trivial matters that don't really relate to the habeas writ involving liberty interest.
Two-part response, Your Honor. The first is that because as the petitioner himself set forth in his application for the habeas corpus, he had not raised this court previously. And under Cobham, the commissioner of the habeas court would not have had jurisdiction over a claim that is challenging the sentence if the petitioner had not previously challenged the sentence either on direct appeal or in a motion to correct an illegal sentence. And the application is very clear that it's just challenging the sentence, not the proceeding, and that he had not raised the claim before. Secondly, and more substantively, what practice book section 2324 subsection 3 discusses is that the relief sought is not available. There is no court, no federal court, no state court throughout the entire country that has extended the juvenile sentencing jurisprudence to an offender who was 18 or over at the time of the offense.
Well,
And in addition, this court, I'm sorry.
Counsel, we're the only state that has the Connecticut Constitution.
That's
I understand that is one of the Geisler factors, but that would be subject for argument for the trial.
understood, Your Honor. Also, at the time, this court had already decided Hockey versus Commissioner of Correction. So, granted, the petitioner in Hockey was 25, but this court had already said in Hockey versus Commissioner of Correction that offenders who have reached the age of 18 are not juveniles, and expanding the application of Miller does not comport with existing Eighth Amendment jurisprudence regarding juvenile sentencing. So,
yeah, but that was Eighth Amendment. That wasn't the state constitution. Miller said that no Connecticut court has addressed this under the Connecticut Constitution. You agree with that, right?
yes, Your Honor.
And Hockey is an example of this claim being raised in habeas, not in a petition for new trial. As is Cassiano, it was raised in a habeas. And in Griffin, it was addressed in a habeas because, according to the Griffin court, your office argued that it couldn't be raised on a petition to correct a motion to correct an illegal sentence.
Yes, Your Honor, I stand corrected. That is correct, that this had not been previously litigated. And Hockey, you're correct, was only federal constitution. The state constitutional issue had not been preserved below, so this court did not address it. So my apologies. So it would be then the procedural basis of the fact that under Cobham, the habeas court did not have jurisdiction over this claim that was raised for the first time in a habeas proceeding, and therefore the habeas court was correct in determining as a preliminary matter that the writ should be returned because the petitioner was not.
So let me, if I can ask you about Cobham. Cobham did not say that the habeas court did not lack jurisdiction. What Cobham says is that if it wasn't raised in a motion to correct an illegal sentence, the petitioner's habeas claim might be procedurally defaulted, which is a special defense, correct?
That is correct.
And in this case, because the court dismissed it, we never got to the pleading stage where the respondent filed a special defense, right?
That is correct.
And even if the procedural default special defense had been filed, the petitioner could file a reply alleging cause and prejudice, right?
Yes.
And those are factual determinations which a habeas court then has to make based on the special defense and the reply. There has to be a trial on those issues, typically, right?
Or at least pleadings. Yes, that's correct, Your Honor.
Okay. And in Griffin, in footnote 3 in Griffin, the Supreme Court said that it did not need to address the issue of whether the petitioner first had to pursue the motion to correct a legal sentence because it wasn't raised as the procedural default wasn't raised. And it appears that your office, in Griffin, when the petitioner filed a motion to correct a legal sentence, argued that that wasn't the right forum. The right forum was habeas. Is that fair?
Well, yes, Judge Wright, but also please realize that at that time, the law was changing so quickly. We were filing briefs, Your Honor, in which we had alternative arguments where we did not know what the jurisprudence was going to be because we did not have decisions from this court or our Supreme Court. At this point in time, the law is a little more settled in the sense that we now do have Delgado under the federal constitution. We do have McLeese under the state constitution as well. So yes, I agree that's what happened in Griffin, but at that point in time, the law was changing so quickly that we did not want to preclude
But
relief.
Cobham was out there. Cobham had been out there for a couple decades. And you still said, in light of Cobham, petitioner has to go to habeas.
I know, Your Honor, but the law is a little more settled now, so I'm more comfortable at this point in time arguing Cobham, but you are correct, Your Honor, that it would need to be pled as a special defense. So in this case, what it's going to fall on, Your Honor, is the fact that the petitioner has not been able to establish before this court that the habeas court, that he actually has a viable claim with regard to the extension of the state constitution to him. Yes, Judge Moore.
Attorney Lupon, in the Omar Miller case, to the best of my recollection, the panel did not require Mr. Miller or his counsel to brief the Geisler factors on appeal because he had not been given the opportunity to have a hearing on his motion to correct. So, but we reviewed his claim and obviously remanded it to the trial court. So why should the petitioner in this appeal be held to a different standard in terms of his alleged failure to have briefed the Geisler factors? Why is this any different in that sense from the Omar Miller case?
Because of the procedural posture, Your Honor. In Omar Miller, as this court had said, there was no procedural mechanism for summary dismissal for a motion to correct. And this court also made clear in Omar Miller that it was not saying that, in fact, there was any merit to the state constitutional claim. What we have here that is different is we do have a summary dismissal provision with regards to the habeas proceeding, so that it is incumbent upon the petitioner at this point in time to show that the habeas court's dismissal or return of the writ was legally and logically incorrect. So it's because of the procedural difference. I'm sorry, Your Honor.
But in both cases, neither defendant or petitioner had the opportunity to have a hearing to present whatever scientific, testimony and evidence they could come up with to present, in support of this theory. And looking at the Geisler factors, do you agree that it would require at least some evidentiary showing, particularly vis-a-vis the public policy factor?
What I would agree with, Your Honor, is that there would need to be an opportunity for a trial court to assess the Geisler factors before making a determination as to whether to proceed with expert testimony. As this court had said in State versus Mukhtar, granted within the context of the federal constitution, because the defendant had not raised a claim or been able to establish an existing right to having the juvenile sentencing jurisprudence extend to him, that the trial court also was correct in not taking expert testimony with regard to that issue because he wasn't able to establish a right. So at least some sort of proceeding, maybe not a full, at least a hearing, but not necessarily an evidentiary hearing with regard to the taking of expert testimony and cross-examining that expert with regard to the state of the evolving science.
All right, thank you.
Thank you, Your Honors.
Attorney Lupon, can I also ask you, your claim that this really was a 23-24 declination of the writ, is that inconsistent with the fact that Judge Kwok then granted the petition for certification as to the state constitutional claim, which would suggest he believed in granting the pet cert that it was a subject that was debatable among jurists or was worthy of further exploration?
Yes, Your Honor, the granting of the petition for certification would suggest that he did think that this was an issue that was worthy for further exploration. However, that does not absolve the petitioner of his obligation to have a fully formulated, fully adequately briefed claim before this court in order to make the determination if in fact that this was something that was merited further review, or if in fact the habeas court was legally and logically incorrect in dismissing this case. So, Your Honors, if I may sum up, it is the Commissioner's position that this case is controlled by Gilchrist versus Commissioner Court, that the timing of the order and the phrasing of the order in the sense that it does specify that the application was being returned, that in fact this is a matter of the habeas court returning the writ based on preliminary consideration under Practice Book Section 2324, subsection 3, and because the petitioner has failed to adequately brief a claim that he is entitled to the relief he requested, which was extension of the juvenile sentencing jurisprudence under the state constitution, because he has failed to adequately present that claim before this court, this court should order a remand to the habeas court with direction to issue an order returning the writ under 2324. Thank you, Your Honors.
All right, thank you, Attorney Lukban. Attorney Rich, you'll have 10 minutes.
Thank you. My client has been working very hard to try to get a working to be able to actually be able to in some manner to be able to get an actual to actually get a to be able to actually he's actually working to try to get a to get through just give me a second, Your Honor. What he's trying to do is get through a program in order to get in order to get a he's trying to get through a program in order to get in order to work his way through a process and in order to he's trying to get a he's trying to get through a I know I'm not speaking well right now, Your Honor, but what he's trying to do.
Can I ask you a question? If your client was looking for a hearing on the state constitutional claim, why not just file a motion to correct an illegal sentence, which the state seems to concede, or the respondent seems to concede, is the proper avenue to pursue, and that's quicker than doing a habeas. You file the motion to correct an illegal sentence, you have a hearing on it, you present whatever evidence you want to present on this public policy issues, and then you make your state constitutional argument in that form.
I would be willing to do that, Your Honor.
Well, Attorney Resch, I don't know that the court's suggesting you do that. I think the court's asking you, why not do that? I think you might have to address the statute of limitations issue with respect to motion to correct an illegal sentence. We are well beyond a 3-year time period, sir.
Yes, Your Honor. My client has been working to try to get through a program in order to be able to progress it. I mean, he's not just sitting there and doing nothing. He's working through a college through a college to try to get himself together. So at some point in time, he could be more than just somebody stuck in a prison for the rest of his life. He has been working to try to get beyond that, and I think that is something to his credit. He's also been doing well in the prison. He's changed his attitudes toward the staff and been doing quite well with that. I think he has the ability to be more than what he is now. I met with him several times. He's definitely a person that has insight and the ability to be more than what he's doing now. I think that I think that he is somebody that can that could progress and actually be a citizen that at some point he would be able to be actually be somebody that could be an asset to our country rather than just being housed in a prison for the rest of his life.
All right, I don't believe there are any further questions. I want to thank you both for participating in the virtual courtroom today. We look forward to seeing you both in the actual courtroom sometime in the near future. We will take the matter under advisement and we will stand in recess until 3 p.m. Thank you. Have a good day.
Thank you.